SJC-12347, Brian Rafferty v. Merck and Company, Inc., and others.
Good morning, Chief Justice.
Wait. Swiftly, hang on. We have to wait for Mr. Keneally. He's quick, but he has lost a step. He's not quite as quick as he used to be. All right, now you can go. All right.
I will start over. Good morning, Chief Justice. Good morning, Your Honors. May it please the Court, Emily Smith-Lee. I represent the plaintiff appellant, Brian Rafferty. I'd like to start by going back to the core allegations in Mr. Rafferty's complaint. In 2008, Merck, as the brand name manufacturer of finasteride, was aware of evidence that its labeled indications and side effects in the United States were likely to last longer than indicated on the label. Merck made changes in Europe, did not take the steps it was allowed to and required to take in the United States to change the label here. Therefore, the label in effect, when my client took the drug, did not reflect these updated safety warnings. Now, at that time, today, and even going all the way back to the days of the Hatch-Waxman amendments, the generic manufacturer that made the drug that my client took was required to use the same language Merck used on its label, did not have the same ability as Merck to institute labeling changes as appropriate. I'd like to back up for a second and be clear what we're not asking this court to do. We're not asking you to create new law. We're asking you to apply established principles of negligence law to a unique set of facts.
Can I ask you kind of a global question? Because
Sure.
When we look at duty of care, we have to reflect social policy, as you well know, and you've debated that very well in your brief. How do we fit the whole regulatory fast track of generics and Hatch-Waxman within that rubric?
Absolutely. You may be sending me to a longer portion of my argument at this point, Your Honor. Yes, you do have to consider policy. But policy is more than what's reflected in the amicus briefs. This is not simply Mr. Rafferty's remedy versus whether it's fair or unfair for brand name manufacturers to carry this responsibility. One also has to consider the key function of tort law, which is to prevent injury by imposing duties on those in the best position to prevent that injury, which clearly in this situation we would argue is the brand name manufacturers. There are other problems with that policy argument, however, Your Honor, that I'd like to address. First, the concept of unfairness kind of brushes right past the period of exclusivity that the brand name manufacturers have under the patent laws and under Hatch-Waxman to recoup their investment on the drugs. Second, and probably more importantly, this argument that they dwindle to a minuscule share of the market when generics enter the market, in fact supports the policy supporting imposition of liability. If they're not responsible for the generic labels, if they've only got a teeny tiny market share, and if they are the entities charged with post-market surveillance, labeling of these drugs, where's their incentive to prevent injury?
Put aside for a moment the Chamber of Commerce amicus brief that the sky is falling. But let's look at what's going to happen in drug prices. So if the drug company is liable past the exclusivity period, they're going to build in liability into the price during the exclusivity period, which is the problem because the price is so high during that period, and it's when we get the generics that there's some relief.
That could happen, Your Honor. The sky is not necessarily falling, however. Whether they need to build a price increase in for some catastrophic liability, in part depends on how carefully they discharge their obligations in terms of post-marketing surveillance, providing adequate warnings. The fact that it's going to be expensive for somebody to breach a duty of care, I would suggest that's the part that is extending our traditional principles of negligence law, not our argument that there is a duty.
In your argument is this is just as simple as foreseeability.
Foreseeability and policy. There is a strong policy component to having the people in the best position to prevent injury be the people who are responsible.
Now, with regard, let's focus on negligence. By negligence, do you mean negligent misrepresentation?
We mean negligent failure to warn, which we do not believe is constrained into a product liability box in the way that the defendants are suggesting.
Okay,
Our starting point with negligence is anybody with a duty has the duty to act or not act reasonably.
But would you need causation,
Yep.
and which would mean that the person would have to, at some sense, rely upon the failure to warn?
I agree.
And is there any allegation here that the person relied upon it?
Perhaps I'm not understanding your question, but I'll try.
Is there an allegation here that your client relied upon the safety information which Merck provided and took that drug where he otherwise might not have taken the drug had he known that the conditions may endure even when he stopped taking it?
I believe that's pretty specifically alleged in our complaint, Your Honor, where we've stopped in this case, and it's on the dispositive question of duty, which is what was raised before the trial court. But yes, absolutely, the allegations in the complaint are the labeling on the drug that he took indicated that these were transient side effects at a time when Merck knew that they were not transient. As soon as my client did some independent research after taking the drug, he found out that that might be the case, stopped taking the drug, and is still experiencing these symptoms 7 years later. So I hope that answered your question, Chief Justice. We do believe that's pretty clearly laid out in the complaint.
Now, what do we do with the Giannakostas case, which says the tort of negligent misrepresentation that results in physical injury is not at this time a recognized cause of action in Massachusetts?
We did not frame this as a negligent misrepresentation claim. We framed it as a negligent failure to warn claim.
What's the difference, really? I mean, is there a difference?
I would argue, Your Honor, there's a higher standard of proof in a misrepresentation claim because you get into the pleading with particularity and identifying a misrepresentation, a statement that was false. What we are saying is that Merck, under our sort of recognized negligence principles, because of its unique responsibility in this situation, had a duty to discharge that with due care. There's no question they had that duty to their own customers. The question is, does that duty extend to generic users? And that's where, we argue there's very little question that those users were foreseeable as a matter of fact. And then you get into this sort of policy realm, which I think I've already addressed.
Okay, well, let me ask one more thing. What if we were to say, well, we're concerned about the policy implications of negligence, but we're not going to permit reckless disregard for safety? Can you still prevail here if there is a reckless disregard standard?
I believe so. I mean, we certainly didn't draft the complaint with that standard in mind. In this situation where it's not just a debate about what the language was and whether it was sufficient, and where Merck actually, we allege, had this actual knowledge, I believe we could. I would suggest that for purposes of future plaintiffs and future cases, that that's setting the bar higher than Massachusetts law requires. If I might, Your Honors, address...
I'm sorry, Justice Lowy had a question.
I want to go back, since we have to, when we're dealing with duty, we have to consider the policy implications. So if this type of liability extends to the generics, the drug company that's got the initial warning has no control. They don't have control over gauging, boy, maybe we should withdraw this from the market. Maybe we should augment our warning, seeing what's happened here after a number of years. The generic has no incentive to do that now because they're not liable because of preemption. So you've got a company that's completely outside of manufacturing on the hook as it relates to liability with no control. How does that impact prices?
So 2 answers to your question. I want to go to the first part. I'm not sure I agree with the control issue. The brand name manufacturer's control is over the label. They do not, you're right, have control over how the generic manufacturer formulates their drug, whether they put it in a capsule, whether they package it appropriately other than the label. But we're not asking the brand name manufacturers to be liable for those acts. Those are on the generics. What we're talking about here is simply the warning. And yes, there could be an increase in price. I'm not an economist. We haven't tried this case, so we haven't, fully fleshed out those issues. But that is not the only policy concern in front of this court. The brand name manufacturer, whether you do anything here or not, already is federally charged with continuing to do this post-marketing surveillance so long as this drug is on the market. If the brand name manufacturer pulls out, I believe there's a mechanism for somebody else to be responsible for that, but I'm not an FDA expert.
Isn't that what some of the courts have said, that within this regulatory scheme, it would be swell if the FDA had put that duty on the generic manufacturers, and I guess your position would be don't hold your breath?
My position would be, yes, that would have been swell. And don't hold our breath. In many, many of these briefs, people have cited the proposed FDA rule that would have changed this and sort of addressed the post-mincing world. I note that that was put out for comment 4 years ago. Nothing has happened. And I do want to use that as a jumping off point, if I might, because there's been a suggestion in one of the amicus briefs that this court should be leery to second-guess Congress. You don't have to interpret the Hatch-Waxman Act. We don't have to agree whether it was a good idea or a bad idea to allocate the labeling responsibilities the way that they did. The job here is what are the implications of that allocation of responsibility on state tort law. So yes, Your Honor, many things would have been swell had they been done differently.
If I can turn you to 93A.
Absolutely.
What is an unfair and deceptive practice with regard to failure to warn?
So the unfair and deceptive practice that we allege is the affirmative withholding of known safety information from the U.S. market.
And do we have any other case in which that has been applied to somebody who was not a purchaser of the product?
So we have, better than a case, Your Honor, we have the statute. There are cases under Section 11 of 93A that require some business connection between the parties. Defendants have cited those in their brief. Importantly, Section 9, which we commonly refer to as the consumer section, is actually drafted much more broadly than that and says, hold on, I wrote it down, any person other than a person entitled to bring a claim under Section 11 can bring a Section 9 claim. There has never been a case requiring that kind of privity in a Section 9 consumer action.
Okay, I understand that, but the regs speak about disclosed to a buyer or prospective buyer. Here you are a buyer, but not of the product of the entity which allegedly engaged in the unfair and deceptive practice. Do we have any such cases where this has been applied in that context?
I'll be honest, I haven't found one that helps me or hurts me under Section 9.
So I'm sorry, your definition of unfair and deceptive is what precisely? I should have written it down, but I did not.
Sure, the Unfair and Deceptive Act that we are alleging is the affirmative decision to withhold known safety data from the label in effect in the U.S. market. It may be a variant on your earlier question, Your Honor, about a reckless disregard standard.
Well, I was going to ask that. Is that different from reckless disregard, or is that just sort of you said it would fall within that characterization?
I would. It's the same core factual allegations, but in the 93A context.
Is that a higher standard than negligence? Not higher, but is it for a plaintiff, a more challenging standard to meet than negligence?
In this case, I would say yes and no. It is, I believe, a higher standard to meet in terms of the badness of the conduct. In this context, I believe it's a lower standard for us to meet, given the absence of any requirement explicitly in the statute of any of the kind of relationships that the defendants claim are lacking here.
I have sort of a basic question that I should know the answer to. If the generic is being produced, does the company that had the patent have any control over changing the label after the exclusivity period has run?
Yes, absolutely. The generic is required to follow the brand name manufacturer's label long after the period of exclusivity. That is the one thing and the key dispositive thing that we argue they have control over. Your Honor, might I just conclude with one quick observation?
You may.
Bring us back to the question as framed by the court, which is where a brand name manufacturer of the drug is responsible for labeling the drug, where a manufacturer of a generic version is required to use the same labeling, whether an individual who takes a generic version can hold the brand name manufacturer liable. And I just want to suggest, if your answer to that question is no, yes, then the person liable will be the person whose act or omission caused the harm and the person in the best position to prevent that harm. There is nothing anomalous about that with respect to negligence law. If your answer is no, there is literally nobody responsible for giving accurate information to as many as 95% of consumers in the Commonwealth. Thank you.
Thank you, thank you. Mr. Newmeyer, good morning still.
Good morning, Your Honor. My name is Richard Newmeyer. With me is David Johnson and Aaron Rice. I represent Merck & Co. I want to begin by pointing out that 35 years ago, this court in Peyton Abbott Labs said, quote, "Public policy favors the development and marketing of new and more efficacious drugs." That's still true today. In Peyton, this court rejected a market share argument, namely all the plaintiff needed to do was prove you made 10% and you're responsible for 10% of the injuries in a class action pending before Judge Skinner. In this case, the request is made to extend Massachusetts law to require a duty to customers, not of Merck, but of competitors of Merck. As a practical matter, this means that Merck becomes the de facto insurer of its competitors and is subjected to unlimited liability. It's worth thinking a little bit about product liability in the United States. If you want to manufacture products in the United States and sell them, and many companies do, you have to face the fact that as a practical matter, you face strict liability. And you may have a good product, but you have to understand there are some risks to somebody being injured or having an adverse effect or claims being made. And you must factor into your price what the cost of that is, or go to the insurance market and ask for an insurance policy, which is also another way of factoring into your price. Here, what plaintiffs are saying to Merck and everybody else as a practical matter is, you not only have to factor it in for your product, but you have to factor it in for anybody that copies your product.
Let me ask you a question.
Sure.
That does not relate to the specific facts of this case. Let us imagine a drug, we'll call it thalidomide, designed to diminish nausea among pregnant women, extraordinarily popular. And let's assume that it has now moved to the generic phase. Brand name manufacturer of thalidomide begins to get information that it's resulting in birth defects among the children of those women. They do not change the warning label on the brand name for thalidomide, and as a result, dozens, hundreds, thousands of children of the mothers who take the generic end up with a birth defect. No liability to the brand name manufacturer of thalidomide for having failed to adjust its own warning.
Your Honor, in tort law, we always have limitations on liability. Under Massachusetts tort law, I can make a consortium claim for an injury to my wife or my family. If my best friend is injured and I suffer as a result, I don't have such a limitation. I don't have any rights. Now, my sister in her argument suggests.
Wait. Is there answer no? There's no liability, I mean, are you arguing that there is no liability
There's
for
no
the brand name
liability-
manufacturer of
There's no
thalidomide?
liability to the brand name manufacturer.
So
who
it's,
did
so
not
they
manufacture.
we were going to permit the brand name manufacturer to endanger the lives of individuals if they engage in reckless disregard for safety, and there's nothing in the law which says we will prevent that.
My sister has overlooked the fact that there is a remedy, and it's in her complaint. These are prescription drugs. You can't get them without a doctor authorizing the drug. In this complaint, it is alleged that the doctor who prescribed this drug did not give Mr. Rafferty the appropriate warnings and get his consent to the risks that he should have been aware. It's alleged that he is a urologist and that he should have given these warnings. And apparently, the doctor agreed to this because he settled the case.
Okay, so
So-
in my example, let's imagine the doctor is not aware of these results and therefore is not in a position to warn them because after all, the brand name manufacturer who has this information has failed to disclose it. Are you saying that there can be no liability against the thalidomide brand manufacturer?
Well, that's a hypothetical question, Your Honor.
I understand, but the
and
question
it-
goes to, should there be at a minimum a duty, should a brand manufacturer be liable for engaging in reckless disregard of safety?
Yeah, Your Honor, I must confess that I haven't thought about reckless disregard as being a theory because I don't read that in the complaint. I don't have the complaint in front of me, or with me today, but it's my understanding that negligence is being alleged.
But isn't this a different ballgame after the preemption case, after Menson? Because now there is no liability other than potentially to your client.
My sister does make that suggestion, and I would merely state to Your Honor that every single court in the United States.
There's three.
Well, I think there's actually more than that, Your Honor.
No, there's three that say otherwise, but not every single court, right?
Oh, I'm
Because
talking
of
about
a-
after mensing. I'm not talking about before mensing. After mensing, every single court that has confronted, has asked that question, has said, no, that doesn't change the rule. And
Because by my count, and I didn't chalk it up pre or post Menson, there's been three courts, Alabama, California, and a Vermont court, right? That have ruled otherwise.
those are all pre-mensing. The Alabama case was overruled by the legislature. And
It
there is
wasn't
that Vermont
overruled,
case.
because they have a new statute, but.
They created a statute that said, the court was wrong. I frankly, I've been to this court a number of times, and I've never, ever seen all the other cases. I've been in a situation where I can say there are 100 cases on my side. All the courts of appeal, all the federal courts of appeals that have addressed this issue are on my side. And I've got 23 jurisdictions, I've lost track of them, are on my side. And I think that's worth considering.
Have
frankly.
any considered whether or not there remains a duty not to engage in conduct which is reckless to human safety or human life?
Not to my knowledge, Your Honor, but I think in tort law, most of the time we're alleging negligence.
Well, I understand, but also, as you know, in tort law, if you go to a baseball game and you buy the ticket and there's a waiver of liability, we honor the waiver of liability for negligence, but we don't honor the waiver of liability for reckless disregard. We still say you're still responsible for reckless disregard even if you've obtained a waiver of liability. So why would we not maintain that as a minimum obligation of individuals in this particular circumstance?
I don't believe that reckless disregard, frankly, is alleged in the complaint. And frankly, the focus of the briefs have not been on, as I understand the plaintiff's brief, has not been on reckless disregard. The focus has been to cite non-product liability cases, especially in the reply brief, and say that in areas other than product liability, some defendants have responsibility for doing something. And of course, the plaintiff, my sister is quite correct that those cases are correctly decided. But one distinction, which is very important, and I don't have the opportunity to reply to the reply brief, is in all of those cases, the defendant has some control over what's going on. Merck has no control over its competitors. Merck could have decided, for example,
By FDA rule in Hatch-Waxman, you have complete control over post-market labeling, correct? You have an obligation to monitor, to survey, and to correct falsehoods in the labeling, exclusively.
I don't think there are any allegations of falsehood in the labeling.
Well,
alleged in the complaint.
you agree that it's your obligation to monitor the market, and if there are any errors in the labeling, to correct them, exclusively you.
I do agree with that, Your Honor, but
Then how can you say there's absolutely no control by your client of labeling?
we have no control over the competition copying the labels and deciding to manufacture that for an unlimited period of time. Merck can decide.
You have no control over them. They have to copy your label.
I understand that, Your Honor. But Merck, for example, could have decided after the 2008 Swedish survey, well, we didn't know about that back in 1992 when we originally put out this drug. This is new information, and we've assessed the risk, and we decide we don't want to manufacture the drug anymore. They could have made that decision. But under my sister's reasoning, they would be responsible for anybody copying what they did. And how can you go into the marketplace and price your drug at a rate that's going to cover your cost if your costs include all the claims that are going to be made against all of your competitors over whom you have no control? That is the fundamental problem with adopting my sister's argument. And I think that fundamental problem is why courts throughout the United States have said to this request, no, we're not going to do this. We're not going to permit plaintiffs to recover against people who have no control over the product. That is...
Well, certainly if you were potentially liable, you could cross-claim and say, the problem here is not a duty to warn. The problem is there's something wrong with their product. That's what made you ill, not the failure to warn. So you would have the ability to claim that what the reason the person became ill was that the generic was adulterated or something to that effect.
Well, I think as a practical matter, the ability to cross-claim or bring, we could bring a claim against the doctor, I suppose, and say, you prescribed this in 2010, and you had information available to you as a urologist that we didn't have, and you should have done this. But that, if there's going to be litigation, that's a cost. That's, if you get to go to the jury, that's a big item that you've got to factor into your drug price. And how can you factor in what your competition is going to be doing with your product? That is the difficulty that, frankly, would impede drugs being ever being used. Because who's to know in 1992 that the FDA says it's okay, all the studies you have say it's okay, and then 16 years later in Sweden, somebody comes up and says, well, wait a minute, we've discovered some adverse effects. In the meantime, the thing has been copied by,
But
God knows how many people.
doesn't Merck have the same incentive to make sure that the label is correct for its own product? Wouldn't you factor it in that way?
Oh, I certainly agree with that, but the complaint in this case doesn't allege that when Merck put out the product, it knew or should have known that there was something wrong. The complaint just alleges the FDA approved it in 1992, and then 16 years later, there was a study in Sweden that showed something that apparently other studies didn't. That's what's alleged.
Then why did Merck change the label in 3 European countries? Why did Merck change its label?
That does not appear from the record, Your Honor. I can't. That does not exist in the record. I can't answer that question.
So, as a matter of public policy, how do we craft a public policy that says that there is no consequence to a pharmaceutical company engaging in conduct which creates a reckless disregard for human health?
I don't think that there's an allegation in the complaint.
Well, I understand that, but let's imagine the possibility that we would say, well, we're concerned about the public policy implications, so we're going to narrow the scope. We're not going to say it's negligence. We're going to narrow it, and we're going to limit it to reckless disregard. Why should we not do that?
I don't think there are any facts in the complaint that are alleged, and again, I must confess I haven't read it for this purpose, that would permit an inference of reckless disregard. I don't think there is anything in the complaint that would permit that inference.
Would that still run afoul of the arguments you've made about a detriment to innovation? If we were to carve out this reckless disregard theory, would that also render support your arguments that it would be detrimental to drug innovation?
Well, frankly, I haven't read, all the cases I've read, and I've read a number of them, but not all of them, have never examined the idea of saying, well, we're going to carve out a little exception here. You can't recover in negligence, but if you can...
I guess the question I have is it not a little exception, that it's still going to affect innovation?
I think it would, Your Honor, and I guess the answer would be how are the courts going to interpret this reckless disregard? And I don't know the answer to that question, but certainly you'd have to factor it in. You'd have to consider it. And heretofore, companies have relied on the idea that you're responsible for your own products and not responsible for other products.
So what do you say about the 93A claim, that what your company engaged in was allegedly an unfair and deceptive practice in trade or commerce? They are a person. They are entitled to bring a claim saying they were injured as a result.
I say that the motion judge was correct in saying that there was no duty to this plaintiff. And if there's no duty, there's no 93A claim.
So you're saying that the duty in negligence should be carried over to 93A, even though we've said that 93A is a little bit different from a
Well,
tort
93 is a little bit different, but, and I think the motion judge did cite a case on this, it's not in front of me, that if there is no duty, there is no 93A exposure. I see my time is
Okay,
up.
thank you.